It's fine, but this is just your freshman level course. We can go a little bit more advanced if you like. It's fine. Whatever you would like to do. All right. So the roadmap for today, as I said, estate planning 101, basic estate planning, wills versus trusts, probate avoidance, powers of attorney for finance and healthcare. That's basically what I'd like to cover with you today. Okay. So what's a will? Well, a will is something that doesn't work for you because you have to be dead for people to read it. Okay. It controls the assets you have that are in your probate estate. What do I mean by that? Well, probate estate means any assets that are only in your name individually when you pass away, do not have a joint surviving owner, or do not have a named beneficiary that survives you. If it's any of those other classes, it's a probate asset, and it would pass under the terms of a will if you wrote one. If you didn't write one, the state of Rhode Island, is everyone Rhode Island or any Connecticut? Okay, the state of Rhode Island will say who will get the assets into the probate estate. So it is best to at least write your own will so that the state doesn't decide where your assets are. Okay. Now, if you keep assets in your own name, even if you said, oh, I have my son or my sister as my name beneficiary and everything, I'm all set. You're halfway, maybe 40% of the way there, because the dangers are, in addition to finding this cat, which they won't be in Westerly, are that if you become incapacitated during your lifetime.
The employee entrance is available for use again. Thank you.
Thank you for that announcement. If you find yourself in a situation where you've done that, you've named someone as beneficiary of all of your assets, and I would say that you are about 40% there. The problem is that a beneficiary only takes when you pass away. If you become incapacitated during your lifetime, who's going to manage the assets for you? And that's a problem in a will-centered plan, because wills only speak after you die. It's a cat. I have a lot of friends that are probate judges, okay? However, I don't really wish my family, friends, or clients to have to go through the probate court process. We have 39 probate courts in Rhode Island. Without reading the screen, anyone know why? Because we have 39 cities and towns in Rhode Island, each with its own separate probate court, with a judge, with their own rules, which is also very interesting, with a uniform fee system. As long as no one argues, it takes about a year to get in and out of probate court when you die. Longer if we have a guardianship proceeding. A guardianship proceeding is also where you'd have to go to probate court if you became incapacitated during your lifetime and couldn't manage your own affairs and didn't have assets either in a trust or with a proper power of attorney. So there's two ways to get to probate court: while you're living and incapacitated, and then of course after you die, if you didn't name beneficiaries on your assets. So, what is a trust? Well, it's an alternative to a will-centered plan. Yes, it really is a bucket. I want you to think of it as a bucket that you can put stuff into while you're alive. If you create a trust, there are many kinds of trusts, but again, this is estate planning 101, so we're going to talk about the basics of trust. If you create a trust, you can be the king and queen of your trust. So I have a lot of people who say, Susan, if I put my assets in trust, I won't have control anymore. Nothing can be further from the truth. With this type of a trust that I'm talking about, you have sole and exclusive use of the assets in your kingdom. You can take them out, use the assets any way you wish, change the terms of the trust, revoke the trust, amend the trust. You can do anything you wish. Change your plan anytime. What's also nice about a trust versus a will is it helps with the incapacity issues and guardianship issues during lifetime. If you've transferred your real estate into trust, if you've transferred your cash accounts, your investments into trust, you don't have to worry about guardianship because the trustee that you've named, that you trust, which is why the word trust is in trustee, that you've named can manage those assets for you if you become incapacitated. So not only does a trust work while you're alive, it also will disperse the assets as you have stated under the terms of the trust after you pass away without going to probate court. What can you put in the bucket? Sure, we're going to talk about all these different asset classes that you may have that we can put in the bucket and advantages and disadvantages, bank accounts, mutual funds, stocks, bonds, life insurance, retirement plans are always a fun topic, annuities, personal property. So real estate. Anyone know how they hold their home? Joint, tenants by the entirety as a married couple, in your own name. Do you all pretty much know how you hold your real estate?
I'm a co-owner.
Co-owner.
That's what they use the term.
Mm-hmm.
My brother and I are co-owners.
So you may own jointly with your brother in one of two ways. As joint tenants with rights of survivorship, which means last sibling standing wins, or tenants in common, which means as each you or your brother pass, your share passes under the terms of your own estate plan. So, right, without seeing the deed, we're not sure. Very different plan of distribution.
Okay.
So these are some of the common ones. Tenants by the entirety. That's only for a married couple. This is a concept older than dirt from across the pond in England. Okay. And what it says is that if you're married and you own as tenants by the entirety, you own an undivided 100% interest in the whole of the property, and it can only be broken by death or divorce. Okay, that's tenants by the entirety from the common law. Okay. Some advantages to that: neither spouse can transfer the property without the other spouse's permission. Okay, can't sell it, can't mortgage, can't do anything without your spouse's permission. If either of you pass away, the property passes to the surviving spouse through probate. It's very nice. Also some extra credit or protection. That's estate planning 202. We can talk about that later. Joint tenants with rights of survivorship. That's how you may own the property with your brother. Or you may own as tenants in common. You're one of those two classes. So joint tenants, rights of survivorship, last person standing wins. Tenants in common, we'll talk about that in a moment. And then of course sole owner, back to guardianship issues. Tenants by the entirety, I think I just discussed this. No probate on the death of the first spouse. No title change without your spouse's consent. The disadvantages to most of these types of structures is lifetime incapacity issues. If one spouse becomes ill, you want to go and you have to either downsize and sell your home, or you want to just take out a loan, retrofit it for an ill spouse. The closing attorney, the bank may say, well, where's the paperwork that says you can speak for your ill spouse? You may end up back in a guardianship proceeding. Not an issue if we've tucked the home into the trust. Kind of the same problems with joint tenancy. One of the bigger problems, obviously, if the couple isn't married, maybe I don't want it to go to the surviving joint tenant. Maybe I want my half to go to my own family. You don't have that option if you structure the property as joint tenants with rights of survivorship. The last tenant standing wins. And again, lifetime incapacity issues for the joint tenants.
Until one decides to give or sell it to the other person, right?
Right, if you were,
They have that option.
yes,
Let me buy you.
you can always do that.
Okay.
Even in a tenants by the entirety situation, you can buy out a spouse. Yes, absolutely. Tenants in common, lots of problems with tenants in common. Usually it happens if parents pass away, they have 4 children, they inherit the home. They want to inherit it as tenants in common because they're going to own a quarter share and they want their share to go to their own family. That makes a lot of sense. It's going to cause probate or incapacity issues on that 1/4 share if they don't sell it or put it into a trust. I wouldn't want people to keep assets in a tenants in common situation for too long. Sometimes it happens after death. Again, the incapacity issues. When you're flying solo, all of the same problems come about.
What does that mean when you're flying solo?
You own the home in your own name.
Okay.
So if you become ill, you have incapacity issues, we may need a guardianship if we don't have a very good power of attorney, and of course if it's not in trust, that is where the probate court comes in. And then when you die, that property's in your name alone, it causes a probate. Where does it go? Hopefully you wrote a will or a trust that says where you want that property to go. I'm going to speak about cash assets next, but any real estate questions? So cash assets, bank accounts, checking savings, money market, CDs, all of that. Those are really nice assets that you can hold jointly with rights of survivorship. A POD, it's a bank term payable on death to a particular beneficiary, or you could be a sole owner. Again, joint accounts. I have someone named on my bank accounts, I'm all set. That's true, as long as you're fine with them receiving the asset when you die, if they survive you. And of course, you do run the risk with any joint account that person can go into the bank and drain the account. POD accounts. These people actually are scaling up this building in Providence. Okay, I took this picture at PVT Fest. That's very risky. But they were fine. POD accounts, payable on death, again, great structure to avoid probate when you die, but do not avoid the incapacity issues during your lifetime. Again, sole owner, like sole real estate, the only one on your bank accounts, causes a probate when you die. Causes incapacity issues if no one is available to manage your assets if you become incapacitated. Any questions on cash? Ways you could structure it? Stocks, bonds, mutual funds, basically the same. They can be structured the same as cash accounts, POD, payable on death, or in the stock, bond world, TOD, transfer on death, where the financial advisor would use those terms. And again, same thing, joint rights of survivorship. Each investor has easy access. But do you want each investor to have easy access? Are they just on for convenience, or do you really want them to be able to go in and use the account?
Well, who's the investor? Is it
You and your brother, basically, if that's the way you're structuring your home, if you structure the rest of your estate that way, he would be the other investor.
Okay.
POD and TOD, the assets pass without probate to the named beneficiary as long as they survive you. Lots of people named minors. That causes another kind of probate in estate planning 202. We can talk about that a little later. That's definitely not what we want to do. Does not protect against lifetime guardianship issues because a beneficiary has no rights while you're alive to manage the account. Again, a loan, accounts in your name alone, the guardianship issues as well. This is another asset class. We call this, in the legal world, tangible personal property. I like to call it anything you touch, dust, or pat, because it makes sense. Tchotchkes, anything that you have around the house, anything that means something to you. Family heirlooms, jewelry, lawnmower. I don't know about the animal down there, but maybe you have something like that. With a trust, you could draw a blanket assignment and transfer all of your stuff into the trust. And then if you wish to leave a family heirloom, a painting to a particular person, you can sign and date a separate document and it gets done and it won't have to go through probate. Questions on stuff? Life insurance. I see this a lot. Young couple goes and gets life insurance, or you're starting a new job and there's a wonderful term policy through your employer. And if they're not married and they name their 2-year-old as a beneficiary, that's a problem. Because now we have a probate. To get the money, we have to have a guardian name for the 2-year-old, maybe 10 by that time, in order to gain access to the monies. And
Because of the age of the
because
child.
of the age of the child.
Okay.
And then if it's one of those really nice policies, a nice $1 million term policy that the couple bought because they travel a lot and they both pass away in a plane crash and the kids get $3 million and they name the children, the insurance company is going to give them the check on their 18th birthday. Don't we all want kids to get a check for $3 million on their 18th birthday? No, we don't. So we have many different options with the life insurance. Naming beneficiaries, of course, keeps us out of probate when we die. Naming minors does not help us at all. Questions on life insurance before I go on? So I don't really know what these guys do in the bucket, but these are most of the things you can fill the bucket with: real estate, cash, mutual funds, stock bonds. You can name your trust as beneficiary of life insurance so that if you have minor beneficiaries, it goes into a trust and a trustee can manage it for you. And of course, personal property, child. Retirement accounts are a very different animal. Generally speaking, it's nice to name individuals as beneficiaries on retirement accounts. This is one asset class. We really don't recommend that you transfer it into trust during lifetime. You do not want to pay, you don't want to pay the state or the feds an income tax, which is what you would do if you actually transferred a retirement account or a qualified annuity into a trust. You'd accelerate the income taxes on that asset class. So we wouldn't do that. Now, of course, if you have minor beneficiaries or just beneficiaries that you don't feel should receive assets outright, you can name a trust as the beneficiary, which works very well. It's not an owner. It just doesn't become an owner until you pass away. And then you write the rules under the trust as to how you want the assets to pay out to the beneficiaries. It's just a much better way of doing it than naming minor children or people that you just wish not to receive assets immediately on your death. You do that with anything that you own in a trust. Like I said, keeping it simple, name people, not trusts, as beneficiaries. However, what happens, maybe you have children, maybe you're worried about a potential divorce of theirs, maybe they have creditor issues, maybe they're minors. These are all reasons to maybe rethink your beneficiary designations and hold assets in trust. It's a case-by-case basis. Some things don't fit in bucket. Parents are the same. Small bank accounts. Rhode Island has a statute. It's a very interesting statute for probate. We have 3 types of probate in Rhode Island. Filing a will without any probate assets. Filing a will, if we have one, where our probate assets do not exceed $15,000. So if from all the banks, everywhere you have, if the assets do not exceed $15,000, it's called a voluntary or small probate, just requires a filing. If we're $15,000 and 1 penny over, it's a full and formal probate. Vehicles, we generally don't want to put into trust unless they're collectibles or boats. There's insurance issues with that. Agreement 202. Stock options, restricted stock units. Generally by beneficiary, we can work with those assets. Obviously, I do, for most people, advocate for a trust-centered plan versus a will-centered plan. But there are some people who, if you don't have any assets to put in them, a will-centered plan makes sense. But regardless of whether it's a will or a trust-centered plan, everyone needs some ancillary documents to round out the plan. Financial powers of attorney. I can't stress how important financial or durable power of attorney is and it should be updated often. We suggest at least every 3 years. The IRS doesn't accept it after 3 years. I'm always changing it regarding what the new laws state. It's really important to name someone to manage either all of your assets, if you have a will-centered plan, or assets outside of your trust, if you have a trust-centered plan. So the largest asset class that you would keep outside of the trust would be retirement plans, qualified annuities, the cars, the vehicles, restricted stock units, that annuities, that kind of thing. Also what the power of attorney function is talking to the IRS or any other taxing authorities, signing tax returns for you, dealing with Social Security disability, a lawsuit, medical malpractice, and getting you to the dreaded nursing home, which we can talk about. Questions on power of attorney?
Yes, here's my question. Power of attorney, you said outside of the trust, because a trust has an executor.
A trustee. The trust as a trustee, a will as an executor.
Oh, okay.
And they can be the same persons.
Okay, so
And it
power
should
of attorney is for what? The trust or the will? Or either?
Neither.
Neither.
So if you have a will-centered plan with a nice power of attorney, the power of attorney is going to work for you in hopefully managing capacity issues while you're alive. The
Okay.
day you die, no one can act under a power of attorney. Although people do, no one is supposed to act under a power of attorney, and the will comes into play.
Okay.
All right, that's when you have a will-centered plan. If you have a trust-centered plan, the assets outside of the trust will be managed by the power of attorney, who also should be the same person as your trustee. Because it's a money job, they should be the same persons. Managing your taxes, signing tax returns for you, dealing with a lawsuit, dreaded nursing home, all of that, power of attorney. But it's just lessens the role if you have a trust. Okay, why is Bill here? Okay. Bill passed HIPAA. It's a Federal Privacy Act. Congress keeps your health information so private that you can't get access to it. Thank you, Bill. You want to give access to certain people if you cannot request your own medical records and billings. So this now we're talking about healthcare. This rounds out the plan: financial powers of attorney, healthcare powers of attorney. You need to name some people to manage your healthcare. Who would you want to have access to your medical records and billings if you were unable to request them yourself? Also, who do you want to name to step into your shoes and make healthcare decisions for you if you can't make them yourself? From a temporary medical condition all the way up to an end-of-life situation and everything in between. Rhode Island has a statutory form. It allows you to name up to 3 persons, 1, 2, 3, in succession. No co-healthcare agents. They don't want to fight in the Rhode Island hospital waiting room. You keep someone on life support, take them off. 1, 2, 3. So we like to do that if we release authorization. Some people also would like a living will. And that's either if you have no one to name under a healthcare proxy, or if all the people that you've named in your healthcare proxy are not available. Then the living will speaks and says that your attending physician can carry out your wishes in your healthcare proxy. Questions on healthcare? Any questions? Yes, he was very excited. This really never happens. It's really not a reading of the will. That's a very basic thing.
Susan.
Yes.
So just going back to retirement accounts and stocks, mutual funds, and typically those all have named beneficiaries. So what role does the trust take with those?
So if you have named beneficiaries on those assets, the trust would have no role. If you're happy with that structure, that's fine. Some people would rather control who gets the assets and how they get it, and even maybe plan for grandchildren or other people. A trust can tell more of a story than you can tell on a change of beneficiary form that says, leave to my son and daughter. A lot of the change of beneficiary forms are very lazy. And if one of your children is deceased, they'll just pay this to your surviving child, and they will not go down to your grandchildren. And that's one reason why I always like to see the change of beneficiary forms and see if there's a way that we can get down to the next generation. It depends, but again, that's only half the story, right? Because as long as you're well and have your full faculties, that plan works very well. If you become incapacitated, someone needs to control those assets for you. The beneficiaries, they can't do anything. It's just a probate avoidance on death. It doesn't help you with incapacity issues during lifetime, which is the bonus of the trust that it does. Any other questions?
We didn't want to talk about nursing homes.
Oh, I can talk about nursing. Nursing, I can talk about nursing. Absolutely. You want to go a little to estate planning 202?
If you have the time.
Oh, of course I do. Good job.
And that includes long-term insurance.
So long-term care insurance is something that you may or may not wish to get. I don't sell insurance, so I'm not going to tell you whether you should get it or not. It helps us in planning. Okay? I'll tell you in Rhode Island, the rules are very different when you're married versus when you're single and widow. Okay, they're very different. So here's the little crash course on that. Married couple. Now, can I draw this a little, Cassie? Okay, let me point to this, because this is a little different here. So, okay, so let's say we have, this is a bucket, which is the trust, right? And let's say that we have put, and I'm sure it does not look like this, your house, some cash, some investments in the bucket, all right? We wrote some rules. We have a trustee. The trustees are the king and queen, husband and wife, right? Okay. And everything in this bucket is gonna pass to the surviving spouse, then maybe to kids or other relatives, all right? This plan avoids this place, the red place, which is the probate court. It's a barbed wire around the probate court because assets and trusts never have to go here. But we're talking about the dreaded nursing home. So what's important to the king and queen's plan, these pens that work, is the power of attorney as well. So the power of attorney is going to name probably healthy spouse and then some alternate. And the trustee is going to be surviving spouse, healthy spouse, alternates. Currently king or queen or whoever is alive. Now, what I call this house here, in the nursing home world where you live now, that's the Ritz-Carlton, okay? That's the Ritz-Carlton. Over here, this is the Ramada Inn. Conveniently, Ramada Inn is the same initials as Rhode Island State Nursing Home, okay? So in a married situation, if the king or the queen needs to leave the Ritz and go to the Ramada, we can put tools in the trust toolbox and in the financial power of attorney toolbox that gets the ill spouse into the Ramada Inn and saves most or all of the assets for the reigning king or queen that stays at the Ritz by using legal Ramada Inn planning strategies. And in Rhode Island, your IRA money, 403Bs, 401Ks, all of that, those are excluded in the Ramada Inn plan, except for the RMDs, the required minimum distributions. Those go to the state. But we can save a lot of the assets for what we call the community spouse when we have a married couple, okay? Now, did that answer that question on the married couple? Because I'm gonna talk about what happens when, well, that's great, Susan, but what happens if we're single, widowed, or we've lost our spouse? One reigning king or queen left. Now what happens if these people, your remainder beneficiaries, call us and say, what are we going to do now? My aunt, my uncle needs to go to the Ramada Inn. They're widowed, they're single. In that case, if we haven't done any other planning, we'll lose approximately 1/2 of the assets in the bucket and anything else you have outside the bucket if you didn't. And none of these assets to the state under the current law. So that's an option. Some people don't like that option, and I have a lot of clients who, whether they're married or not, they say, you know what? I want to give my assets away. And you can do that. You can abdicate the throne, become a serf, and give your assets to your intended beneficiaries, particularly a home or a second home is what most people would do. As long as you're healthy for 5 years from the date that you make that transfer, you can go to the Ramada Inn, and that asset is outside of their purview. But you have to give up some control. So there's another technique, but it's really boring and long.
What
So that was
control do
really
you give
enough.
up? What control do you give up?
You lose the home or whatever asset it is that you wish to put into this. It's called an irrevocable trust. I call it the serf trust, where you abdicate the throne, give it up. And if you do that,
Right.
you don't own it anymore.
Okay, but the person you give the house to, like, say my mother gave us the house,
Mm-hmm.
we let her live there.
You let her live
Yeah.
there. Yes, you did.
Okay.
Yes,
So
you did.
Okay, so if everything's in good terms, they're not yours. Okay.
Right.
Today.
Right. Right, exactly.
Okay.
Yes. Now, I'm sure when your mother did that, she probably just made an outright transfer to you and your brother. I wouldn't advise that. I would make the transfer into a trust for the benefit of the children, because if through no fault of your own, you get in a car accident or you get divorced or you have a creditor, your mother's house is exposed,
Right.
which isn't her house anymore, right? Because she gave it to you.
Right.
But that's where you really have to look at it that way.
Right. Okay.
So long-term care insurance does help supplement that. And some of the newer policies, I'm told, can keep you in the Ritz too. And some people can self-insure and never need to go to the Ramada, which is wonderful. So that was a little 202. Nice.
No, there's just some cases where there's one person left and eventually they have to go to a nursing home and the house would just sit there and rot because they didn't make any plans. So you have to wait for them to die, probate takes it. I've heard stories about that.
Had they structured it into a 5-year?
Probably not.
Probably not.
If they were the last person, they'd be like, what the hell, I don't care.
Right.
I mean, you know.
Right.
So that just has, people have to wait that out.
Mhm.
Okay.
We had some other ways to get assets to children through a beneficiary deed, which you cannot do in Rhode Island anymore, but if you did it prior to 2014, it works.
Mhm.
There was another trust that you could use prior to 2000, which also is an option, but can't do that now. Any other questions on anything? Okay, well, congratulations, your certificates are over there, you passed the class.
Thank you very much.
You're very welcome.
Thank you.